Welcome to the first instalment of our employment law webinars. I'm Andrew Crammond, employment barrister at Trinity Chambers, and I'll be talking to you about recent developments in holiday pay. You'll also hear from my colleague, James McHugh, who's going to be talking to you with a practical guide with respect to interim relief in the employment tribunal. So starting with my topic, I want to analyse some of the more recent developments in holiday pay. And in particular, there are two areas I want to focus upon. The first of which is an interesting issue which arises out of a Court of Appeal decision in Northern Ireland in the case of Agnew and the Chief Constable of the Police Service of Northern Ireland, which provides an important and interesting update on the issue of whether or not the question of a passage of 3 months breaks the chain in a series of deductions for unlawful deduction of wages, primarily relating to holiday pay, as was the conclusion and the rationale in the well-known case of Bear Scotland and Fulton decision. The second, but equally interesting issue is with respect to a decision in the case of Gary Smith and Pimlico Plumbers Limited in the Court of Appeal. And the decision in that case provides an important update with respect to the entitlement of an individual to recover pay for annual leave taken, albeit not paid for, and the issue of whether or not that individual can effectively carry over unpaid annual leave from 1 year to the next. Starting then with the first issue, which is the question, what I think is a tense question now between the decision in Bear Scotland in the EAT as against the decision which was made in the Court of Appeal in the Northern Ireland in the case of Agnew. The big question we are all currently left with as a result of these two, what may be seen on their face as competing decisions, is whether or not the passage of 3 months of time in a series of deductions ultimately breaks the chain, such that they are no longer a series of deductions with respect to holiday pay. Now, without dwelling on this in any great detail, the general background to this can be found in the provisions of the Employment Rights Act 1996, and primarily the question of unlawful deductions of wages, which can be found within Section 23 of the 1996 Act. In very general terms, a claim must be brought for holiday pay pursuant to the terms of the 1996 Act within a period of 3 months from the date of the deduction. However, there is a provision which allows for the claim to be brought within 3 months from the end of a series of deductions. And it's this phrase, series of deductions, which finds most focus in the Bear Scotland case, and more recently Agnew, and another which I will come to, which is the Pimlico decision, which I outlined at the commencement of this webinar. Turning first of all to the question of Bear Scotland. Now, Bear Scotland was decided by Judge Langstaff, who was then the president of the Employment Appeal Tribunal. And he analysed, and we're all probably very familiar with the rationale of Langstaff now, on the question of a series of deductions. In relation to that, he concluded that for deductions to form a part of a series, it was necessary to establish a sufficient factual and temporal link between them, and that these features were likely to be clearer within a short time after the deduction occurs. He referred to the legislative context in which deductions from wages were claimed, and primarily the reference to what we as employment lawyers are well familiar in most cases as being the 3-month time limit to bring various and multiple claims when enforcing one's employment rights. The important passage of the decision by Langstaff is in paragraph 81 of the decision. And I'll try not to go through this in any great detail for you all, but he says as follows: since the statute provides that a tribunal loses jurisdiction to consider a complaint that there has been a deduction from wages unless it is brought within 3 months of the deduction or the last of a series of deductions made, Section 23, it goes on, unless it was not reasonably practicable for the complaint to be presented within that 3-month period, in which case there may be an extension for no more than a reasonable time thereafter, I consider that Parliament did not intend that jurisdiction could be regained simply because a later non-payment occurring more than 3 months later could be categorized as having such similar features that it formed part of the same series. The sense of the legislation is that any series punctuated from the next succeeding series by a gap of more than 3 months is one in respect of which the passage of time has extinguished the jurisdiction to consider a complaint that was unpaid. Now that is in large part paragraph 81 in full, but I encourage you all to read the judgment in full. But on that basis, in the Bear Scotland case, Langstaff ultimately concluded that, or construed, a series of deductions to mean 2 or more deductions which are no more than 3 months apart. Any longer than that, by way of a gap between deductions, was not sufficiently connected. It didn't satisfy the temporal link, which Langstaff and the Employment Appeal Tribunal said was necessary in order to fulfil the legislative intent behind a series of deductions provision within Section 23. Now, the upshot of this decision, as we probably all have seen as lawyers, is that ultimately it has a potentially very restrictive cutoff. It means that those individuals who have 6 months gaps between their holiday pay being not paid are out of time for the previous. If they have 2 months, they're in time. And indeed, the decision in Bear Scotland has been criticised on occasion for ultimately producing what may be categorised as arbitrary results. So we then jump forward in time, and we are faced with what I think is a rather difficult conundrum. And I call it a conundrum for this very reason. We are faced with the decision in Agnew, the Court of Appeal in Northern Ireland. And it's a conundrum because ultimately the Court of Appeal in Northern Ireland isn't binding on our employment tribunals. However, the Employment Appeal Tribunal is. And the reason it's a conundrum is as follows. Within the case of Agnew, among various other issues, which I'm not going to go into for the purposes of this webinar, but I do say this. The decision, in my view, in Agnew is a very straightforward, well-written and easily understandable decision. And I do indeed encourage all of you to read it wherever you are able. But it deals ultimately with the question of a series of deductions, the equivalent legislation in Northern Ireland, but which is materially similar, and the point, I think, has some bearing in respect of our own tribunals and the employment tribunal system analysing and applying the question of a series of deductions. In particular, I would draw your attention to paragraphs 97 onwards of the Court of Appeal's decision, which in summary was as follows. 1, there is no statutory definition of what amounts to a series of deductions. 2, series, in quotation marks, is an ordinary word, and though in the context of that case, it was to mean through a series of time. 3, whether there is a series of deductions through time is a question of fact and should be left ultimately as a question of fact for any tribunal or arbiter dealing with it. 4, the Court of Appeal makes the interesting and I think quite right point that a series of deductions through time does not have to be what they describe as metronomic, so that each deduction in the series occurs at exactly the same time interval. A series of deductions can be constituted by deductions with a sufficient frequency of repetition, but occurring at different time intervals, and the Court of Appeal stressed, in also different amounts. Fifthly, the deductions do not need to be contiguous and lawful deductions. That's not a requirement for there to be a series. And the Court of Appeal, in summary, at point 6, makes a very important point, which is this. The claimant doesn't have to establish that every payment made to him during a particular period of time was the subject of an unlawful deduction of wages. What the Court of Appeal said is that when one looks at the connection between the various deductions, they are sufficiently similar to create a series because they're all deductions which relate to and are in respect of holiday pay and the non-payment of holiday pay. Seventhly, there has to be a sufficient similarity of subject matter such that each event is factually linked with the next in the alleged series in the same way as it is linked with its predecessor. That was rather a follow-on point from the one I've just described, but ultimately in the context of holiday pay, the Court of Appeal is really saying as long as each of these deductions relate to holiday pay, there is, in the Court of Appeal's position, likely or could well be on the facts of each individual case, a sufficient connection between them. Ultimately, the Court of Appeal found that regardless of questions of overtime allowances or other allowances, that they concluded actually the opposite of what the EAT found in Bear, Scotland. They concluded that a series of deductions was not broken by the passage of 3 months or more between the varying unlawful deductions of wages in cases where there was this unifying feature which could connect them all temporally and otherwise by virtue of them being deductions in respect of holiday pay. And the Court of Appeal, quite rightly in my view, was at pains to indicate that we need to look at the fact that a deduction or a series of deductions remains a question of fact for a tribunal. And the Court of Appeal was simply unable to agree with the decision in Bear, Scotland. Now, it's understood, and I should say this, it's understood that the decision of the Court of Appeal has been appealed to the Supreme Court. I understand it's currently stayed. I'm not aware that that has been concluded in any way, shape or form, so there may well still be a decision on appeal from the Supreme Court. But it strikes us, or it strikes me certainly, that unless and until we have a resolution in the Supreme Court to that question, if there is one, I used the word conundrum. We are, as lawyers, left in a bit of a conundrum, as are claimants, employees, and probably their union representatives and advisors alike. And that then takes me to what I said was the second of the issues in this case, arising from the Pimlico, the long-standing and historical decisions in the Pimlico Plumbers litigation, which has been ongoing. But before I turn to the thrust of that case, we have had, in that case, Lady Justice Simler weighing in on the question of the 3 months gap. Now, it transpires in the Pimlico Plumbers case, the Lady Justice Simler didn't need to make a determination on the question of the 3 months gap, but she did give some obiter comments, and they are, to use the language of Lady Justice Simler, comments which indicate a strong provisional view of Lady Justice Simler sitting in the Court of Appeal. Now, I said this earlier, but I absolutely say it with respect to this decision, one must read the entirety of this decision. And on this point alone, I would direct you in particular to paragraphs 99 to 101. Now, I won't go into the detail of those paragraphs for present purposes, but it is right to say that Lady Justice Simler is correct in describing what she says is a strong provisional view. And ultimately, the conclusion of that obiter, provisional view, and it must be seen in that context, this is not a binding authority, but it's a very clear steer, in my view, towards the Agnew line of thinking of the Court of Appeal in the Northern Ireland and against the thinking of Bear, Scotland in the EAT. Now, where that takes us, who knows? Because if you're in the employment tribunal and there's an argument around whether the 3 month gap breaks a series of deductions, you have a tribunal faced with the following. A binding decision of the Employment Appeal Tribunal, which says the answer is yes, 3 months does break this gap, set against a non-binding Court of Appeal decision in Northern Ireland, but which may be considered persuasive, and likewise, perhaps even more persuasively, albeit obiter, the comments in Pimlico Plumbers supporting the rationale in Agnew. You may feel in the circumstances it would take a rather brave employment tribunal to go against, actually, the binding decision of an employment appeal tribunal. It may ultimately be that if you have cases like this on your desk, you end up in the employment tribunal, you may lose in the employment tribunal, of course, fact depending, and you may find that you end up having to progress it through an appeal in order to get a successful conclusion if you represent a claimant who has suffered unlawful deductions of greater than 3 months apart from one another. It remains to be seen, and I'm sure it can't be long until something of this sort makes its way through the judicial system from an employment tribunal decision sitting, whether it be in England, Wales or Scotland. That then leaves me finally with the other issue which I wanted to address you on, separate from the 3 months gap point, and this is in the Pimlico Plumbers decision now, and I'll address you on this probably in rather shorter course than the 3-month provision. We have all probably heard of the background in the Smith and Pimlico Plumbers case. There was a long-fought battle as to whether or not Mr. Smith was a self-employed independent contractor or whether he was a worker entitled to all of the employment rights which a worker is given within the employment legislation, primarily the 1996 Act, working time regulations, etc. The conclusion was that he was a worker. Subsequent to that, then there was litigation brought by Mr. Smith with respect to a number of holidays he had actually taken but wasn't paid for during the life of his employment with Pimlico. And the background to this arises from a case of King and Sash Windows, in which the European Court of Justice held that workers must not be prevented from carrying over and, where appropriate, accumulating until termination of employment paid annual leave rights, which have not been exercised by the employer because the employer refused to remunerate the worker for that leave. Now, that is the backdrop to the subsequent Smith and Pimlico litigation. And Mr. Smith said, well, hang on, I've taken leave, but I wasn't paid for it. And the reason I wasn't paid for it is because my employer, Pimlico, told me that I wasn't a worker and I was treated as an independent contractor throughout, and I was accordingly denied my rights to paid annual leave. Not simply annual leave, but the right to paid annual leave. Employment Appeal Tribunal, on appeal by Mr. Smith, agreed with the Employment Tribunal. Mr. Smith then appealed to the Court of Appeal, and the Court of Appeal tells us otherwise. The Court of Appeal allowed the appeal, and they concluded that Mr. Smith's appeal should succeed. And what the Court of Appeal said was that a worker cannot be said to be exercising that right, i.e. the right to paid annual leave, in a situation where they've taken unpaid leave when the employer has disputed the right and has refused to make a payment for that annual leave taken. But ultimately, we have a decision here in the Court of Appeal, which arguably has rather significant ramifications, because where workers who have historically been denied their worker status, which you may think is increasingly likely in what's become an increasing world of a gig economy, that worker may well now be looking to bring greater, more substantial claims in the Employment Tribunal. Now, it remains to be seen whether the Court of Appeal's decision will be appealed to the Supreme Court, but it strikes me in summary that we are left with currently a world of increasing claimant-friendly decisions with respect to holiday pay, and the breakdown, or what might be the impending breakdown of the 3-month rule, coupled with the decision in Pimlico on the question of how far back one may be able to go and for which annual leave periods they're entitled to recover, may well see an increasing likelihood of claims not only being brought, but of claims being brought for a greater sum of money from employers. That's all I have to say, and I'm going to pass you over now to James McHugh, who's going to tell you about interim relief in the Employment Tribunal. Thank you.
Hello everybody, I'm here today to talk to you about interim relief and give a short practical guide to interim relief in the Employment Tribunal. So first question, what is interim relief? Interim relief is an emergency interlocutory procedure similar to an interim injunction in the county court that is available to claimants in the Employment Tribunal who have been dismissed on certain limited grounds. Those grounds broadly relate to either trade union or health and safety activities, education and training activities, or whistleblowing. I've produced a short handout with this talk that will go through the specific categories under which you can claim interim relief. As identified by the Northern Irish Court of Appeal in the case of Bombardier Aerospace and McConnell, The purpose of obtaining interim relief is designed to preserve the status quo of the employment relationship until a full employment tribunal hearing can take place. Often it is difficult and expensive to obtain an interim injunction after dismissal to restore the employment relationship, not least because normally the county courts will say that damages are an adequate remedy to put the claimant in the position they would have been but for the unlawful dismissal. So interim relief is a cheap and quick way of obtaining relief for a claimant in those certain limited and specific cases where that relief is available. In essence, what a successful interim relief application does is enable the tribunal to make an order which prevents dismissal from taking full effect, either by reinstating the employee into their role, re-engaging them in a similar role on similar terms, or making an order for the continuation of the employment contract, which effectively works like an order for suspension on full pay, together with any other associated benefits of employment like pension contributions, which would take effect from the date of the dismissal until the conclusion of the employment tribunal claim, whether that be by disposal at a final hearing or settlement between the parties. An extremely useful summary of the history and legislative development of the rights to interim relief can be found in the judgment of Mr. Justice Kavanagh in the case of Steer and Stormshire Limited, which is a 2021 Employment Appeal Tribunal decision. The full citation again will be provided in the short handout that accompanies this talk. In essence, it is an area that has been developing gradually since 1975. So what is the process of starting an application for interim relief? Well, just like with its counterpart in the county court for an interim injunction, time is of the essence. And time and acting quickly really is the most important thing for a claimant to do in relation to bringing an application for interim relief. In any case where a claimant thinks they have been dismissed for one of the specified causes that would enable you to make an application for interim relief, the claimant has to bring their application to the tribunal no later than the period ending 7 days after the effective date of termination. An employment tribunal has no jurisdiction to hear an application for interim relief after that period ending 7 days from the EDT, and unlike with other provisions for limitation, there is no saving provision that means a tribunal can consider complaints either where it would be just and equitable to extend time, as in discrimination complaints, or where it wasn't reasonably practicable to bring a claim or bring an application within the 7-day timescale as you would expect for an unfair dismissal claim. So it really is crucial for a claimant seeking to exercise a right to bring an application for interim relief to do so within 7 days of making the application. Speed is also of the essence for the tribunal, who, according to section 128 of the Employment Rights Act, must hear an application for interim relief as soon as is practicable after receipt, whether an ET1, a corresponding ET1, has been lodged or otherwise. And once a hearing is listed, then similarly, according to section 128 of the Employment Rights Act, the hearing of the application cannot be postponed unless the tribunal is satisfied that special circumstances exist which would justify it from postponing the application hearing. There is a further additional step that is required for claimants who wish to rely on the trade union related activities head of applications for interim relief. And in those cases, not only do you have to get your application in within 7 days, but also in accordance with Section 161 of the Trade Union and Labour Relations Consolidation Act, the claimant must also, within that same 7-day period, get a certificate from an authorised union official that confirms that at the date of the dismissal, the employee was a member of that trade union, and also that the union confirms that there appear to be reasonable grounds for supposing that the reason for the employee's dismissal, or if there was more than one reason, the principal reason for that dismissal, would be that they were acting in relation to union activities. If the claim gets listed quickly enough, the respondent's employer doesn't need to be given much notice of the hearing, provided that they've been given notice of the application hearing and a copy of the application no later than 7 days before the hearing. The tribunal deems that to be sufficient time for them to prepare. Once you get to the hearing stage, the next question is, what does the tribunal have to consider? Well, practical steps first. Applications for interim relief are normally by default heard by a judge sitting on their own. And the usual position is that a tribunal doesn't need to hear any oral live evidence unless it specifically directs for that to be the case. And again, given the provisions for things to take place quickly and the emphasis on things to take place quickly, it is usually the case that interim relief applications are heard in the absence of any oral evidence. The EAT has given recent guidance in the case of Queensgate Investments LLP and Millet that interim relief applications are to be treated like other substantive preliminary hearings, and that therefore they should be heard in public, just like you would deal with a PH on the issue of limitation or disability status or some other substantive PH like that. In all applications for interim relief, the main question for the tribunal to determine is as follows. The tribunal has to look at whether it appears likely that on determining the complaints to which the application relates, the tribunal will find that the reason, or again if there's more than one reason, the principal reason for the dismissal is one of the specified reasons that I've already set out in the talk earlier and in the handout. The question then is, and the key phrase is, it is likely. What does it is likely mean? Well, there's been a couple of appellate court authorities on this point. Taplin versus Shipham, which is a 1978 EAT case, set out that it is likely ought to be interpreted as the claimant having a pretty good chance of succeeding at a final hearing. It's commonly accepted, both in the case law and the academic commentary, that pretty good chance is a high threshold for the claimant to have to meet, much higher than its counterpart for obtaining an interim injunction in the county courts. The EAT in a 2011 case of the Ministry of Justice and Safraz stated that likely connotes a significantly higher degree of likelihood than the usual more likely than not balance of probabilities test. It is worth bearing in mind, though, that this is not supposed to be a mini trial. Speed and efficiency are the key provisions, and in a 2013 decision, the Employment Appeal Tribunal in the case of London City Airport and Chaco emphasised this. What they said was that the statutory test for interim relief is not whether the claimant is ultimately likely to succeed at the final hearing, but whether it appears to the tribunal that it is likely to be the case at the interim hearing on an expeditious summary assessment of the untested material available to it. Further clarification was provided by the EAT in 2020 in the case of Simply Smile Manor House Limited and Terberg. And what that clarified was that the likely to succeed test has to apply to every aspect of the complaints that the claimant would be required to prove at tribunal. So in the Simply Smile case, there was a debate about whether interim relief would be available, because at the final hearing there was to be a dispute about whether the claimant was an employee and therefore able to claim unfair dismissal for the purposes of the Employment Rights Act. What the EAT concluded was that there was no problem with the Employment Tribunal at first instance determining that question of worker status, as long as it applied the same approach of whether or not there was a pretty good chance at final hearing that the claimant was likely to establish that they had the relevant status for the purposes of their employment tribunal claim. So to summarise in relation to that, it's a judge alone, it's got to be dealt with quickly, and the key test is the phrase, "it is likely," which is a high threshold. Additionally, there has been some academic debate in relation to trade union related cases where the claimant has obtained the certificate that I mentioned earlier in this talk as to what influence that should have. In the Chaco case, the EAT seemed to suggest that that was just one piece of evidence amongst many that the Employment Tribunal had to weigh up. The academic commentary is different, and certainly the commentary in Harvey on industrial relations seems to suggest that an Employment Tribunal ought to be slow to disregard the judgment of an experienced trade union officer when they put their view on paper, put their money where their mouth is, as it were, that this person has been dismissed for union-related activities. Probably one to be tested at appellate level. So if a claimant is successful in an interim relief application, what is the next step for the tribunal to take, and what order can a tribunal make in favour of a successful claimant? Well, the first thing that they have to do if a claimant is successful is ask the employer whether the employer is willing, pending determination or settlement of the final claim, to reinstate the employee and effectively to treat them in all respects as if they'd not been dismissed. They've got to ask that first. If the employer's not willing to do that, they then have to ask whether or not the employer would be able to re-engage the employee on another job on terms and conditions that are no less favourable than those which would have been applicable had they not been dismissed. No less favourable includes, according to Section 129 of the Employment Rights Act 1996, similar conditions in relation to seniority and pay. If the employer is not willing to either reinstate or re-engage on similar terms, or they fail to attend the application hearing before the tribunal will make an order for the continuation of the employee's contract of employment on the same terms. And as I'd set out at the start of this talk, how that effectively manifests is it's as if the employee is suspended on full pay pending the conclusion of the employment tribunal claim. Where it is reasonable for them to do so, if there is an offer to re-engage the claimant in a different role, the employee can refuse that offer of re-engagement, but the employee needs to tread carefully, because if they fail to accept a reasonable offer of re-engagement, that can be grounds for the employment tribunal to refuse to make an order continuing the employment or granting the interim relief as sought. One of the huge practical benefits, however, for a claimant of obtaining an order that continues their contract of employment is that even if they end up unsuccessful in their ultimate employment tribunal claim, they will not be required to repay the wages that they receive for the period that the interim relief is granted. And obviously this has practical benefits for a claimant in terms of placing settlement pressure on a respondent between the interim relief hearing and the final hearing at tribunal. One last point relates to the scope of interim relief and an attempt to expand the scope beyond the limited position now which relates to usually whistleblowing and or trade union related activities. The recent case of Steer and Stormshire Limited, a claimant backed by the Equality and Human Rights Commission, sought to extend the scope of interim relief protection to all dismissals which contravened the Equality Act 2010. The claimant in Steer alleged that she was dismissed and that dismissal constituted sex discrimination, and argued that it was a breach of both EU law and the Human Rights Act that interim relief was not available to her as a remedy as somebody who'd been dismissed in contravention of the Equality Act versus somebody who'd been dismissed for trade union activities and or whistleblowing. That has been dealt with by both the Employment Appeal Tribunal, who found that there was no breach of EU law, and the Court of Appeal recently, who concluded that the lack of interim relief wasn't a breach of the claimant's human rights. But that matter is currently with the Supreme Court. The claimant has made an application for permission to appeal the Court of Appeal's decision to the Supreme Court. We still await the outcome in relation to that. And as Mr. Justice Kavanagh observed in his judgment in the EAT, if the appeal ultimately succeeds, the legal landscape regarding the remedies that are available in discrimination and victimisation cases will change significantly. So that's one to watch for the future. Thank you very much for listening to this talk. As I said at the start, there will be a handout available on request. And if there are any questions, please don't hesitate to get in touch with Chambers, who will be able to forward them on to me. Thank you very much.